All right. Welcome to topic 6, corporate governance, directors and officers for Company Law of Papua New Guinea Unit. This is part 1 of our discussion. First off, we have to distinguish first what it means by director and board. So when you say director, that is the person occupying that particular position for the company, and for the purposes of section 112 to 119, 123 to 127, 344 and 350 of Companies Act, it says here, a person in accordance with whose directions or instructions a person referred to in paragraph A, which is on top, may be required or is accustomed to act. The second one is a person in accordance with whose direction or instruction the board of the company may be required to accustomed to act. A person who exercises or entitled to exercise or who controls or who is entitled to control the exercise of powers which, apart from constitution of the company, would fall to be exercised by the board. A person whom a power or duty of the board has been directly delegated by the board. So which means if the board had delegated that power to a particular person, that person will be treated as a director. A director in this act does not include a receiver, where the constitution of the company confers a power on a shareholder which would otherwise fall to be exercised by the board. Any shareholder who exercises that power or who takes part in deciding whether to exercise that power is deemed, in relation to the exercise of the power or any consideration concerning the exercise, to be a director. Now take note, it's referring to a shareholder which were given power by the Constitution to act as if he is a director. So that person will be treated as a director also. Where the constitution of the company requires a director or board to exercise or refrain from exercising a power in accordance with a decision or direction of the shareholders, any shareholder who takes part in making a decision that power should or should not be exercised, or making any decision whether to give a direction, or as the case may be, is deemed to, in relation to making any decisions, to be a director. So again, if the Constitution requires a shareholder that particular decision making, that shareholder will be treated as a director. The board or board of directors, as the Companies Act define, will be first a director or directors of the company who number not less than the required quorum acting together as a board of director, or where company has only one director, that director. Now in letter A, it's explaining that when you talk about board and not all the directors are present, as long as there is a quorum, that will be treated as a director. Rule of thumb, quorum is of course more than 50%, but the constitution of the company can make a requirement on how many or what will be the percentage of the directors attending the board meeting to make it as a quorum. Now, if one director only, that director will be treated as board. Powers of management. Powers of management, with regards to that, Let us first discuss management of company. The business and affairs of a company shall be managed by or under the direction or supervision of the board of company. So the oversight should be done by the board of the company. The board of a company has all the powers necessary for managing and for directing and supervising the management of the business affairs of the company. Again, those supervision and oversight power will be vested into board of directors, but the day-to-day operation will be done by the management. When you appoint a director, the appointment must satisfy the requirements of Section 129 of Companies Act 1997. So these are a natural person, not a company. Another one, consent to the appointment in writing in the prescribed form and certify that he or she is not disqualified from being appointed or holding office as a director of the company. Be over 18 years of age. This is important because this is the legal age. Not be a person who prohibited from being a director or promoter of or being concerned or taking part in the management of the company. You can see these provisions on sections 425, 426, and 428. Not be a person who is or becomes of unsound mind. Now, we don't want a director or a prospective director to be an insane person. We don't want those to be running our business. So that's fair. In relation to any particular company, not be a person who does not comply with any qualification for directors contained in the constitution of that company. Now, there are requirements that can be set by company constitution when they want or they will elect director. Okay. So they can make it a much stricter and high eligibility for future directors. Of course, we want the best to run and oversee the company. When a new company is registered or two or more companies are amalgamated or merged or having merging, the registration form or amalgamation proposal must state who is or are to be the directors. It's important, of course. We want to identify those directors who will be overseeing the operation of the company. Subsequent appointments of directors will usually be made by an ordinary resolution of shareholders. However, the company's constitution may specify another method of appointment. So the law says ordinary resolution will be the way to appoint the director. Again, company constitution may require or may propose a different way in appointment of the director. The shareholders of the company must generally vote for each director individually, although the Constitution may alter this requirement. The shareholders have the power to decide how long directors are to remain in office before their appointment needs to be voted again. The term of office is usually specified in the company's constitution. As in the case of Port Moresby Stock Exchange, listed companies, no director is able to hold office for more than 3 years without being re-elected. The directors can resign at any time. Of course, they have to provide proper notice. The notice must be in writing and delivered to the address for service of the company. The notice is effective from the time it is received or such later time as is specified in the notice. So, for the appointment, we also have to discuss about removal of directors. Subject to constitution of the company, a director of a company may be removed from office by ordinary resolution passed at a meeting called for the purpose or for the purposes that include the removal of the director. The notice of a meeting referred to in subsection 1 shall state that the purpose of the meeting is the removal of the director. We don't want surprises, so we have to mention the purpose of the meeting. It should be stated there. Directors may be removed from office either by shareholders of the company convening a meeting to do so, or they may be removed by a court. So meaning if there are case pending and then the court decided, the court can remove the director. Ordinary resolution of shareholders is one of the ways that the company can remove the director. Section 152(1) of the Companies Act 1997 grants to the National Court the power to remove a director where a shareholder, former shareholder, or entitled person establishes that the affairs of the company has been or being or are likely to be conducted in a manner that is, or any act or acts of the company has been, are, or are likely to be oppressive, unfairly discriminatory, or unfairly prejudicial to him or her. If you can recall our discussion about the rights of the shareholders, and the shareholders feel that the acts of the directors are oppressive and unfair, and also unfairly prejudicial to the shareholder, they can file a case to National Court to remove the director. If a person is disqualified from holding the office of director, that person automatically ceases to be a director at that time of disqualification. If a person convicted of certain types of offenses, he or she is automatically disqualified from being a director or being in any way, whether directly or indirectly, concerned or taking part in the management of the company for a specified period. So, if they are disqualified on holding that office, it is automatically, right away, the director will cease to be a director. The following are disqualifying periods mentioned by the law. Okay, it says here, where the person was sentenced to imprisonment during the period of imprisonment and during the period of 5 years after release from the prison. So if the director had been sentenced to be imprisoned, that's the starting time of the disqualification of the director. So meaning automatically he will not be a director. Then afterwards, if he is being released from prison, plus 5 years. Another one, during the period of 5 years after the judgment or the conviction. So meaning you'll wait for 5 years for the judgment. Then the person can be qualified again. But during that time, during this period of 5 years, he is or she is not qualified as a director. What are the offenses that automatically disqualify a director? It says here, conviction on indictment of any offense in connection with the promotion, formation, or management of the company. And then those offenses mentioned in sections 420 to 423 of Companies Act. Or any crime involving dishonesty, whether within the country or outside the country. A person with problem or having issues on his or her mental state may also be grounds for disqualification of the director. So these are sections 420 to 423 which may or will disqualify the director. So first is false statement, second is fraudulent use or destruction of property, falsification of records, carrying on business fraudulently. And that's it for our discussion on part 1 regarding directors. Thank you.